She could die anytime she uses it. It's a substance where when obtained illegally, you don't know what's cut into it or its concentration. So if you make one.
I can recall at least 5 overdoses where you have died and had to be brought back by Narcan. Is that I also have to have that hammer hanging over your head because you don't want to be revoked. And
what you just saw were a glimpse into a life on the edge. Brianna Bearheart has survived death 5 times. But this courtroom battle isn't just about drugs. It's about a judge who's done waiting. Brianna stands here for methamphetamine possession. Yet District Attorney Kevin Schmidt knows the real killer is her heroin addiction. He warns that one miscalculation is all it takes for her to never wake up again. But the real shocker? Brianna's chillingly casual response to her own 5 overdoses. Now, the judge is tearing up the agreed-upon plea deal to hang a prison hammer over her head. Is this tough love, or is the system finally giving up? At stake is more than prison. It's her very survival. To understand the high-stakes psychology used by judges to save lives in the courtroom, hit subscribe for more deep legal analysis. Let's go back to where this sentencing hearing began.
we will go on the record in the matter 26 CF11, State of Wisconsin versus Brianna Bearheart. The state appears through District Attorney Kevin Schmidt in person. Ms. Bearheart appears in person in custody with counsel Eugene Harrington. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Harrington, please recite for the record.
Then I'll plead to count 1. Count 2 will be dismissed. 2 years withheld sentence, 2 years probation, costs, DNA surcharges, successfully complete drug court, any and all other conditions by the Department of Corrections.
All righty. That's the agreement that you've reached, Ms. Bearheart?
Yes, ma'am.
Have you been to prison before?
I got sentenced to prison, but I had so much time credited that I didn't.
You never actually went?
No.
All right. And Mr. Harrington, are you aware why she was sent to prison, or can she just tell me?
She can try it.
Okay. Why were you sent to prison? For what? Do you remember?
No, I don't.
Was it Burnett County?
Yep.
Do you remember a year?
Last year, two years ago, maybe.
Oh, was it? Yeah, after you had all of those cases. Yeah. Right. Okay. Got it. Got it. So that refreshed all of my recollection. All right. Okay. So that's the agreement that you've reached. Is that correct, Ms. Bearheart?
Yes, ma'am.
And I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you?
Yes, he did.
Did he go over it thoroughly with you?
Yes, he did.
Word for word?
Yep.
And you understand everything completely?
Yes, ma'am.
And that is your signature on the second page?
Yes, it is.
You are pleading guilty to 1 count of possession of methamphetamine. You're 35 years old. You have 14 years of schooling. You can read, write, you understand the English language. No mental illnesses or disorders, no drugs, alcohol, or other medications, correct?
Correct.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, he did.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document. Did your attorney thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yes, I do.
And do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand you'll no longer have the right to a trial? You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have the state prove your guilt beyond a reasonable doubt. And you will no longer have the right to have a jury of your peers reach a unanimous decision. If I said that as guilt or not guilty, you will not be able to testify or remain silent. Okay, I just want to make sure I've went over all of those rights and you understand them.
Yes, I do.
Do you understand that you're pleading guilty to a felony, as such will no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in any election until your civil rights are restored?
Yes, I do.
Do you understand here the state would have to prove on or around January 17th, 2026, you possessed a substance. The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both.
Yes.
Do you understand that there is an agreement that's been reached here today in which they're providing a joint recommendation to the court for 2 years of probation with what's called a withheld sentence, and you successfully complete drug court? Do you understand? I'm not bound to follow that recommendation.
Yes.
Said differently, I could sentence you to the maximum possible penalty, and I could do so today.
Yes.
Do you also understand that I can do something called an imposed but stayed sentence instead of a withheld sentence?
Yes.
Do you understand what the difference between an imposed but stayed and a withheld sentence?
Yes, no difference.
Do you need me to explain anything about that to you?
No.
All right. Now, did you go over, did I ask you if you're not a citizen of the United States, your plea could result in your deportation?
Yeah.
Yes. All right. And did you go over the criminal complaint with your attorney? And in particular, that section called the probable cause section, where it's basically saying what happened that day and why you were charged with the crime?
Yes, I have.
And for the most part, are those facts accurate?
Yeah.
All right. Ms. Bearheart, are you pleading guilty to possession of methamphetamine because you were guilty of that crime?
Yeah.
Did you in fact possess methamphetamine?
Yes, I did.
Mr. Harrington, may the court use the probable cause section of that criminal complaint to find a factual basis?
Yes, Judge. In addition to the criminal complaint, I obtained the discovery, the video discovery, and spent considerable amount of time with Brianna going through that before we came to the decision to make this plea. The factual basis is sufficient.
All right, thank you. Has anyone made any threats or any promises to you, Ms. Bearheart, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, ma'am.
As to count 1, possession of methamphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I would ask the court to consider placing the defendant on probation and ordering her to apply to drug court and if accepted, successfully complete it. Brianna Bearheart has a very lengthy criminal history going back 20 plus years. The history reflects she struggled with substance abuse her whole life. The substance she's convicted of today is not her drug of choice. It's not what she's usually caught with. This was methamphetamine. She does have a prior conviction for amphetamine, pled down from methamphetamine from 10 years ago, which itself was a case where the methamphetamine was in conjunction with morphine. Her drug of choice has been heroin or opioids in general. She's been around a lot of people who have methamphetamine over the years, and it's been present around her. The main concern, I think, for Brianna Bearheart is we see in her history that the criminal history is obviously connected to the drugs. So there's a compelling purpose to want to get her sober for that reason. Even more compelling is we know from informational reports from law enforcement that she's overdosed numerous times. The substance that she does use, that is her preferred one, is a dangerous one that has a high risk of killing her. She could die anytime she uses it. It's a substance where when obtained illegally, you don't know what's cut into it or its concentration. So if you make one miscalculation, that could just be it. Narcan has been very effective in saving her life for years, but that'll only last for so long. I think that given her history, there's no doubt she's done the full gambit of different types of treatments and therapies and groups and all that gambit before. I'm hopeful that with drug court, rather than being slotted into some sort of one-size-fits-all program, she can be worked with to develop something that she could benefit from, that can prolong her life and hopefully allow her to live a full life. I think this is, in fact, a harm reduction sentence. I think this is something that needs to be done for those purposes, for her benefit. This is a sentence that is heavily driven by a need to rehabilitate the offender for the purpose of life. And so I'd ask the court to follow the sentence. Thank you.
All right, Mr. Harrington.
Gravity offense, this is a serious offense. It's a serious offense because possessing controlled substances, particularly methamphetamine, is a danger to society in general, but it's really a danger to the people that possess it and consume it. And that's a serious offense. Brianna Bearheart is 35 years old. When I first talked to her, I asked what she was doing in her life. She has enrolled in college, has 14 years of education. She was studying law. I don't remember, civil procedure or something of that sort. And she would like to continue those studies for law. We've had a number of conversations over the last 3 or 4 weeks about where she goes from here. And I stressed to her that she freely admits that she's an addict. She's addicted to heroin, and it's screwed up her life. She's a mother of 2 children, a 17-year-old and a 15-year-old who are living with their dads. Her mom is here. She'll live with her mom when she gets out of jail. She's currently serving a sanction, and that's up on the 16th. She applied for drug court, and I think the team was going to meet today. My information was from Tessa Anderson, that the team was going to meet today and make some sort of a recommendation, whether she's accepted or not. Our reason for trying to get this from the status yesterday to a plea today is that then the drug court team will know whether she's available for drug court or not. And we think that'll be helpful in having a favorable recommendation by the drug court team. She's been to treatment before. She's been to counseling. She's been to inpatient things and outpatient things, and has a checkered past with the use of substances, possession of substances. We all know that people that are addicted oftentimes fail the first, second, third, 20th time until they don't fail. They succeed. Brianna is now sober. She told me, and I trust that she'll tell the judge, she is tired of being addicted and using addiction, active addiction, and she just wants to step out. She has potential employment at the tribal store between here and, well, it's at Hurdle. And that was part of the bail modification request that I filed. She's been receiving her per capita, and actually I think the per cap has been going to her mom, and her mom is paying some of those unpaid court costs for Brianna while Brianna's been in jail and other places. This appears to be, to me, an appropriate disposition given Brianna's mental status right now, and notwithstanding the significant criminal history, this appears to be an appropriate disposition of this particular case, and I urge the court to follow. Thank you.
All right, thank you. How many days of credit does she have today? I count 78.
January 17th to today.
Oh, the 17th to today?
Yes.
All right. Okay, Ms. Bearheart, is there anything that you want me to know?
No. I don't know. I think drug court would help me. Give me something to do with my time instead of being bored and going out and getting high. I want to go to school. That's about it.
Okay. So then I think I get 81 days of jail credit.
Look at 84, but
I said from January 17, 2026 to today is 81 days. That's what I put in little Google and Google spit that out.
if that's what Google said, then that must be correct.
I will believe.
I'll tell you where I made the mistake. I counted 30 days in February.
Oh,
We
yeah.
all know that there are 30 days in February.
There are not. No, I trusted Google to tell me. So it says 81 days since January 17, if that's when she was arrested. All right. So Ms. Bearheart, you have, I know you, you know me, you've been in front of me for multiple cases. You originally had $1,000 cash bond in this case because of your significant and substantial failure to appear rate or absconding rate.
Mhm.
Because the last time I sentenced you was just a couple years ago,
Mhm.
and I was still waiting on your 2015 case to resolve that. And I think that was just at the very end of either taking the plea or sentencing when it just then got through the loop and then additional charges and all of those things. This isn't the most serious, but it is serious when I look at you, because I do know that you have a substance abuse disorder. And I do know that it is heroin.
Yeah.
And I know that there have been, I think, that I can recall, and I only know what I know, what I've been told in here, at least 5 overdoses where you have died and had to be brought back by Narcan. Is that correct?
Probably, yeah.
Yeah. And so that scares me because I told you that before the last time. It scares me for you. It scares me for your kids. It scares me for your mother who is here. She's been here with every one of your cases. I think
Yeah.
everyone.
Yeah, she has.
She has been a great supporter. Sometimes maybe enabling a little bit, but hopefully she's going to come down and not be hard on you, but be tough, that tough love, because you are such a bright and beautiful person when you're sober
Mhm.
and when you're present and when you're contributing. And I don't want you to die.
Thank
On meth, less likely, okay? On heroin, very likely,
Mhm.
especially now when fentanyl is being thrown in there, okay? That scares me. I am going to order that I will do the probation, 2 years of probation, and I am going to order that you apply for drug court, and if accepted, you successfully complete. All
Mhm.
right? And I'm going to tell you, based upon your history and the fact that you do appear to be high risk, high needs, you will be accepted into drug court. So
Mhm.
you're going to be there. You're going to, and it's not a, okay, well, I'm going to get out of jail and I'll just wait and I'll just have some things to do. When you are released from custody, if you are accepted into drug court, you are running on your feet right then. You have to start, making arrangements, making sure that you have a place to stay, your mom's, that you are starting with your AODA assessment, that you're starting with your therapies, that you're starting with your group counselings, that you're doing those things. It's not I have some time to chill and relax and get comfortable. It's immediately you are on the ground running with drug court, with treatment court.
Yep.
It's going to be hard and it's going to be tough. And I'm going to tell you that you're going to have times where you're like, I just can't do this.
Mhm.
But the Brianna Bearheart, I know, you are determined when you want to be.
Yes, I am.
And I'm going to tell you, you also don't like people telling you you can't.
I don't. Can't
So,
stand that.
no. So, exactly. So, you like to show people that you are in control and you can do what you want. So, do it and be sober and give your all to the treatment court, because I want to see you on your path of recovery, and I want to see you beating the substance abuse disorder.
Mhm.
Okay.
Yeah.
So I am ordering the treatment court. I'm not following the recommendation for withheld. Here's why. And Mr. Harrington may know this, he may not, with regards to the Court of Appeals decision that came down in a one judge county. I have to do an imposed and stayed, or I'm not going to be able to sentence you, and I have to get another judge to do it. I don't like other judges having my cases when I know the people, okay? Because I know you. Another judge won't know you, okay? And I need to give you the incentive to not want to be revoked and to do well in treatment court. And I also have to have that hammer hanging over your head because you don't want to be revoked and you want to do well in treatment court. So I am going to sentence you to 1 year, 1 month of initial confinement with 1.5 years of extended, no, 2 years of extended supervision. You may need the aftercare if you are revoked. It's imposed but stayed, okay? Because I want you to do well on treatment court. I want you to want it, and I want you to want to prove to everybody in this county and in this world that you can do it. And otherwise, you'll have to, for real this time, go to prison and see what it's like. I don't think you're going to like it.
No,
I don't want to see you there, okay? So that's why I'm doing what I'm doing. What I'm also going to do is, I know that your mom has been working with you with your per capita and trying to pay down your fines and fees. I do have an idea and a thought of what we can do if you're able to save a lump sum of money and to be able to wipe it all out completely. But you are going to have other fines and fees with treatment court. If you're interested in that, if your mom and you talk and you say, is there an amount that we can pay to get judge at least off my back with the fines and fees, because that's totally separate from treatment court. You can still be held in contempt and sit time in jail for failing to pay those fines and fees, again, aside from treatment court. I am willing to do that. Just write a letter, just say, Judge, I just want to be heard, and then we'll go over that, and I will see what a lump sum is that we can waive and get you clean, fair and square. Okay, done deal. Okay. So think about that. So I'm only going to assess the $250 DNA surcharge here because, quite honestly, you still owe fines and fees. You're going to have other fines and other fees for treatment court. And I'm just going to try and give you a little head start as much as I can right now. I am going to tell you though, and here's another reason why I'm not following the recommendation, but I'm going to tell you why. And this isn't a punishment to you. And it's not because I don't want to see you get released after your sanction day is over, but I am going to do 93 days of conditional jail with 81 days credit. So I'm not going to make you sit an additional full 90 days with 81 days credit. So you're going to have to sit another 12 days. Here's why. Because I am going to be gone on the next treatment court because I'm going to be at the treatment court conference. And I want you to be released on a weekday so that you can meet with Dave Hatch and you can talk to Tessa Anderson. You can meet with Leah, your DOC worker, who's going to be your worker, and that you will be able to be released during a weekday. So all of that can happen and you can be informed and told these things instead of a weekend. And then I don't want to lose count of you. I don't want, things to go awry. I'm trying to do things in a way that I can see and feel will be in your best interest to have you hit the ground running in a good and positive way. So the conditional jail, it's not a punishment per se. It is a punishment, but it is designed so that you can be released on a week and time where you're going to be able to have that in-person contact. Okay? You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. Condition. I do need your DNA. The jail will make sure that you get that, or that we get that. You have the ability to request it be expunged through a written letter to the Department of Justice. I did some conditions, and I hope you got those, the drug court, those kinds of things. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Testing upon reasonable suspicion, blood, breath, urine, or hair. I think that's all that, because you're gonna have to get a job and maintain employment when you're in treatment court. I'll just put that on, maintain gainful employment. I think that's all the conditions that I'm seeing. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Harrington?
Nothing, Judge, except the court imposed the condition that she's subject to hair follicle testing.
That's actually through the treatment court.
She used on January 17th, and recognizing that her hair is just a touch longer than mine, she may have some residue.
That's fine. I'm gonna tell you, she won't have
Oh, no.
hair. You're not gonna have hair follicle testing until you're in treatment court, and if I'm not believing you or trusting you, because that's what treatment court is. So it's just on a condition just in case, and it won't happen anytime soon, but thank you for that information so that we have that. Anything else?
Any questions?
Mhm.
No, Judge.
All right, thank you. Then we are adjourned.
Any questions?
Okay, no, no. I think I'm good.
The judge made her call. Brianna walked away with probation, but that 1-year prison sentence is officially hanging over her head. But here's the question. Was the judge right to reject the plea deal and use fear as a motivator? Comment below. Team Judge or Team Brianna? Is a prison hammer really the best way to force sobriety? If this case got you thinking, hit like. Share this with anyone who loves real courtroom drama.